The appointment committee has programmed the acting Chief Justice, my Lord Bafuboni, for vetting on Monday, the 10th of November. Mr. Speaker, we are here to approve the Business Committee's report as a House. And the rule allows us to amend, reject, modify the report that is presented to us. It is my contention that in view of precedents of this House, in respect of matters involving the rule of sub judice, this House cannot be invited to accept the vetting of the nominee for the office of Chief Justice, when indeed there are pending constitutional matters before the Supreme Court of this Republic and before the ECOWAS Court of Justice. Mr. Speaker, just for the avoidance of doubt and to lay a proper foundation for the submission I heretofore make, I shall rely on the official report of this House dated the 5th of March 2025. I will start from column 140 and read portions of column 142. Quote, Mr. Ayariga, Mr. Speaker, that is the point I'm making. The point I'm making is that there are two grounds on which I'm raising the objection. The first ground is that under our Constitution, we must not interfere with the work of the judiciary. So if the judiciary is already seized with a matter, Parliament should not also take up that same matter and refer to it as Human Rights Committee. Parliament would be interfering with the work of the judiciary. Under the Constitution, we owe the judiciary a duty not to interfere with their work. And my argument is that we're taking up the matter and referring it to our Human Rights Committee to also inquire into what would be interfering with the work of the judiciary. That is my first argument.
I recognize the Chief Whip.
Very well, Mr. Speaker.
For some time.
You may recognize him.
Speaker, may I humbly draw your attention to Order 71, Rule 1, 2, and 3. Speaker, the business before the House is the presentation of the business statement and comments arising therefrom. Mr. Speaker, the minority leader on his feet is not addressing matters arising out of the business statement. Please, 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 please. Please, 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 please. Please.
Honorable Deputy Whip, are you on point of order against point of order? Point of order against point of order?
Mr. Speaker, Mr. Speaker, Mr. Speaker, I have not yielded. I have not yielded. Mr. Speaker, these are very serious matters. The minority leader instead of speaking to matters arising out of the business statement read, he is seeking to bring in a matter that is before the court, and to seek to say that Parliament by that process is injuncted from performing its constitutional rights, and is referring to a matter that arose some time ago from the Hansard. In any case, the courts have decided. In me, I was in court in Dafeamakpor versus Attorney General, when I sought to enjoin this Parliament from vetting ministers nominated by the President at the time. The Supreme Court told me that I cannot enjoin this Parliament from performing its constitutional rights and functions. Additionally, our own brother Asefo went to court. The court told him, Asefo versus Attorney General, that this Parliament cannot be injuncted from performing its constitutional rights. So the matter is settled. So the minority leader cannot seek to rehash a matter that's already been settled by the Supreme Court. He's wasting our time. So if Mr. Speaker, if the minority leader intends to raise an issue arising out of the business statement,
if you don't want to listen, others are mindful of listening.
It should do so. It should stop bringing in the vetting, the scheduled vetting of the CJ on Monday, because that one, it will happen. This House will perform its constitutional rights and duties. The Supreme Court has already settled that
Majority
matter.
will be brief.
A mere filing of a case. In other case, Mr. Speaker, the matter before the court is a certiorari application.
Majority whip, be brief.
It's a certiorari application.
Honorable Majority whip, be brief.
Yes, Mr. Speaker, I'm being brief. But let us settle the matters on the law. The application before the court is a certiorari application. There is no injunction application before the court. It is an application of certiorari seeking the Parliament, the court should prevent Parliament from performing its constitutional rights. And that application will be heard at a definitive date. But in the meantime, the Supreme Court says Parliament must continue to perform its constitutional rights. So that matter, the minority leader shouldn't go there. It is settled. It is right. It is settled, and he knows.
Honorable members, I intend to give the floor to Minority Leader to conclude.
Mr. Speaker, I come to this chamber prepared and fortified. I don't make lame submissions. A member can preside to make statement ex cathedra. I would rely on authority, and that is what I seek to do, and I move on a ground of relevance. Mr. Speaker, I was on a path of quoting Mr. Ayariga. I'll continue. He continues, and my argument is that we are taking up the matter and referring it to our Human Rights Committee to inquire into. We'll be interfering with the work of the judiciary. That is my first argument. He continues at paragraph 1. He continues at 142. This is what he says. Even though ordinarily we will wait until the person is making a statement and we think the statement is going to prejudice the interests of parties, then we object. But here, I am saying that the very language of the motion should already prejudices what it is saying we should do and what it is saying we should not, apart from offending the Constitution. We say we should not interfere in the work of the judiciary. In moving it, there is no way that he will not say things that will not prejudice the interests of parties in substantive litigation. Why the hurry? End quote. That is Ayariga. Mr. Ayariga, the majority leader of the 9th Parliament, invited the Speaker to hold that because there was a Nana Boakye case at the Supreme Court. By the way, the government of his objection was the fact that Henry Nana Boakye had filed a constitutional matter at the Supreme Court. Therefore, my application should not be moved at all, which objection was sustained by the Speaker. Now